people are waiting for us.
Yes.
So, and it's compelling also, needful that you advise and also put through as to what happened in court today. We are going to speak the English language for the benefit of those who are not understanding the Igbo language. So, because last time some people were actually asking questions, they are not understanding what you are speaking in Igbo language. So, of course, you know, this project cut across the African nation and other places.
Yes.
So today the matter came up for ruling on application to vacate the order, revoking bail granted Onyendu sometime in 2017. Then I know opposition to that revocation of his bail in 2017, the bench warrant was issued. So, however, we promptly filed an application to set aside in 2019. We promptly filed an application to set aside that order revoking his bail in the same 2019. And that application was filed on the first day of May, the first day of April 2019. Served on the prosecution, and they responded, and we also filed our reply on point of law. From that 2019, 1st of April, it was filed, stretched to 2022. We have repeatedly brought that to the attention of my Lord, the court, that we have this application. Because this application sought in substance to explain to the court what led to the disappearance of Onyendu Kanu, what happened in his place on 14th of September 2017, how the military invaded his premises, how 28 persons were murdered there in cold blood, how he narrowly escaped being killed. And more so is the fact that these are facts clearly verified on oath by Onyendu Kanu when he was in Israel. So he stated, because it's evidence of an eyewitness, he was there, he's the victim. So he stated clearly what transpired in his house, how he managed to escape. So, and this evidence and evidence is very compelling for the court to understand also. I give it a serious weight. But unfortunately today, the court delivered the ruling, and we understand that the court said that there was no application that was filed before her except this year. That we waited till 2022 to file application to explain his whereabouts. That we also, that has been addressed, because I understand that may be it's an error which is seriously on because the application was filed on 1st of April 2019. So it was filed promptly. And that application is very compelling. If it was given meritorious consideration, I believe that the ruling of today would have been different. Despite the fact that court said we can still come back to him, and also with further information and facts regarding to what happened in his house on September 14, 2017. However, we have gone on appeal. We are now before the Court of Appeal challenging the charge, challenging the returning of the 7-count charge out of 15 by the court. So, and we followed it up to ensure the appeal was entered in good time, and also have an application, a motion to hear the appeal speedily. Of course, under the Court of Appeal fact-track direction, the appeal of first session is such which fall within classification of the appeal can be had speedily. And we also followed it up with an application for accelerated hearing, which has been, which court has magnanimously given us 11th of October for hearing. It hasn't happened before. So, and we believe that from the look of things and from the position of things as it stands in this court today, that we'll get justice in the Court of Appeal. So obviously, because 3 heads better than 1. So we are trying on our appeal, including the one of the one of final respect of the ruling delivered today. We are going to also appeal against it too. So, however, and based on the persuasive argument of Nestle, who is now leading us, she was looking at SAN, the court has stayed proceeding to the court on the matter. So the court will no longer, in general institution, entertain this case again, pending determination of the matters, or the appeal will file before the Court of Appeal. So we have other serious applications or serious suits before the court, which will, one way or the other, determine the entire proceedings. And we are of the view that when this appeal is heard, appeal also challenging the returning of 7-count charge before this court, and when it's heard and determined, most positively, I can assure you that will be the end of the case, and now they cannot walk out. So, as you have heard him in court, he continued to advocate for peaceful conduct and civility, and he continued to advocate. In fact, he was forced to say it out today, because we know that you people most times are being provocated, are being tried to go into certain activities that may probably lead to arrest. But we have to avoid it because we know what we are passing through today. So our prayers for you is that you go back to your various destinations safely. And while you are traveling, you have to be very careful because have a lot of enemies now who are all over the places looking for who to devour, but it will not be your portion. And we are assuring you that we're not resting our oaths. All the lawyers in this case, we're not resting to show that Onyendu is out, and he will be out soon, and it will be total. Thank you so much for coming. God bless you exceedingly, and also grant you safe journey back to your various destinations, and remain blessed. Thank you so much.
Thank you so much. You say what?
Airports and famous the Nigerian government, if they do not release Nnamdi Kanu, this election will not, this Nigeria will not contain all of us.
I'll convert to you.